All right, we're giving this a try. My audio has been not cooperating. Can you guys hear me, or is there an echo? I know there's a few of you in here, so hopefully somebody will help me out on this. Bob, I know you're picking on me about always having the issues, but I swear you had to deal with the level of whatever is going on here. Okay, so there's a bit of an echo, but I'm just going to ignore it, and hopefully you guys, you do hear it. Well, let me see. Let me turn off. Maybe. All right, can you hear me better now? Maybe not. It's driving me insane. Anything better with that? Or this? Is that better? All right, this is going to drive me insane. Okay, I'll maybe keep the audio further away. No, that doesn't help. All right, give me a second here. I'm going to switch to just being on. Give me a second. Ditch this audio while I do it. All right, is that better? Can you hear me at all? Larry, I think you gave me the ticket. I know. Judge and I had all this drama trying to figure it out. So, can you guys hear me okay? Cash me outside, Kevin. Yeah, exactly. All right, I'm going to guess that the audio is working good now. The trick is, thank you, Larry, to turn off my speakers. So, jury duty, and I will just X out maybe if I can figure out how to edit that out from the beginning. So, jury duty in Michigan, if you are registered as a voter at the Secretary of State, you're going to be on a list of people that are in the jury pool. So maybe once or twice a year, you will be getting a notice in the mail, and they have email and text messages now, where if you are in the jury pool that is selected for that particular couple of weeks or months or whatever, you may get called for jury duty. So your first step is to thanks, Dennis. Your first step is to figure out, how to fill out the form. It's not terribly difficult, and honestly, the forms aren't super helpful to us. So the form asks you about your occupation, your spouse, and their occupation. Have you ever been the victim of a crime or been involved in an accident, or somebody close to you been involved in an accident? Those sorts of things. So, a very basic questionnaire. Those questionnaires, though, go to the defense and the prosecution and the court, obviously. And if you are in the jury pool, then you are able, the prosecutor and everybody are able to look at those ahead of time, so we can get an idea. Are there people that I know, people that are maybe going to have a bias because they've been in an OWI accident, or they've been convicted of a crime or something like that? So it's not terribly difficult to fill them out. And honestly, I think the easiest method, based on my family and friends that have been on the jury pool, is to use the text messaging option. So that way, if the jury is canceled for some reason, instead of having to call in the number at the court the night before you're supposed to report and find out, you can get a text message and know right away. So that way, if you had planned to be off of work or something, you can let your boss know, and then you show up at work that next morning like you're supposed to. So once you then have filled out that form, that's not the end of it, right? You got to pay attention because at some point you may get called in to be in the jury pool that's actually at the courthouse for a jury trial that is set. If you're in the district court jury pool, then you're looking at a 6-person jury. Sometimes they may do an alternate depending on how long the trial is expected to last, but most of the time you're going to be just 6 people because a district court trial, you're looking at maybe a day or two for most of them. If it's beyond a day or two, that would be kind of unusual. There's not typically that much information that needs to be put on as evidence for a district court jury trial. A circuit court jury trial, on the other hand, you have 12 people. You're required to have 12 seated, and typically you have at least one alternate. Depending on the length of the trial, you may have more than one alternate. I want to say the last murder trial that I tried as a defense attorney, we had 2 alternates just because it was expected to last a week or two. I think we had it set down for 2 weeks, but it ended up lasting maybe a week and a half. So that is a long time. Things happen. People get sick. Family members get gravely ill, and if they can't get there on the days that are required, and you only had 12 people seated, you may end up in a mistrial and have to redo everything. So, if it is your jury pool day, you gotta show up and you gotta be on time, right? Not terribly difficult. And there's a lot of sitting around and waiting. It just is what it is. Sometimes there is a last minute plea deal. Sometimes we're waiting for witnesses to show up, maybe the victim to show up. Sometimes it's just a matter of making sure that all of our jury instructions are proper. So we try to do a lot of that ahead of time. So especially in circuit court, the judges in our county are he's very particular about making sure that there's no blurry areas about the jury instructions. So our witness lists are finalized ahead of the jury pool coming in. Our jury instructions are finalized ahead of the jury pool coming in, so that when the jury gets there, we can jump into what we call the voir dire. So it's kind of like fancy sounding, but it just means Q&A session, right? So the voir dire is done in our county by the judge. Now we can supplement any of the questions that we might have for the jurors depending on the type of case. But generally, the judge asks all the questions. It is different in different jurisdictions. Sometimes it's the prosecutor and the defense attorney asking the questions completely. Sometimes it's the judge with some help from the prosecutor and the defense. But in our county, generally, it's the judge. So what happens is it's not like all 50 of you or 100 of you that are in that room are answering the questions every time the judge asks them. They pick the numbers. They pick your 12 people to fill those 12 seats, or sometimes 13, again, or 14 if we have the alternates. And so out of that, it's a randomized number. They used to have what looked like a bingo ball, right? Like the way you twirl them around and you pick out like the little balls. But now it's done with computer. And so they'll call the names in order. So you go the 1 through 12 or 1 through 14, and you have to sit in order. You can't just sit willy-nilly wherever you're at. So wherever you're seated, you got to sit in that seat. And we have a chart in front of us that is given to us so that we can keep track of who gets seated where. So with the prosecution, generally I have my witness, my complaining witness as the investigating officer sitting with me, not my victim. So that is a little confusing because there are times where I worry that maybe if the victim were in there and they got a bad feeling from one of the jurors or whatever the case might be, they may want to use one of our peremptory strikes to get rid of that person. Not for any particular reason. It can be any reason, basically. But there's also then the defense who gets their peremptory strikes as well. We each get 5, I believe it is, in our circuit court jury trials. So as the 12 or 14, whatever, we'll go with 12, easy, right? 12 people get seated. The judge then asks very basic questions. So it's kind of awkward at first because the judge will ask if any of the people in the jury pool that are sitting there know any of us, the defense attorney, the defendant, myself, or whatever prosecutor is handling it, or anybody in the prosecutor's office. So I have to name off everybody who's in our office. Or any of the other witnesses, including the police officer that would be there with me, and a list, whether it's a long list of people or a short list, whoever it might be called as a witness in the case, we list off their names. Sometimes if people are known by a different name, then we have to say, okay, well, so and so, but also goes by this. So we try to figure out if there's any right off the bat issues with people that might know one of us. Now, I'm from a small town, right? I grew up in Centerville. I've lived in St. Joseph County most of my life, so that can be a bit challenging. So that there's a difference between just knowing somebody or knowing of somebody versus having that affect you to the point that as a juror you don't feel comfortable saying that you can give an unbiased look at all of the evidence presented. uh, Mortimer Duke, yeah, just you can't handle the truth. Yes, some Tom Cruise moments on these trials, but not really. I mean, trials can be very boring, which I think maybe is why people have a desire to get out of jury duty. Correct, you don't get a ton of money for showing up, right? But you cannot get fired for being there, and you do get that jury stipend. I forget how much it is, but it's not a ton, and some mileage, I think, too. But anyway, going back to the choosing then. So the very basic is, do you know any of the people involved? Have you heard anything about the case? Most of these cases, people aren't going to have heard of anything about it. If it's a run of the mill drug case or something like that, most people, they may know the police officer. Oh, I've seen this police officer. Well, is that affecting your ability to make an unbiased decision? Well, yeah, because he gave me a ticket and I didn't think it was right, or I think that he's, untrustworthy, or whatever the case may be. It can also go to, I I believe the police, and anything a policeman says, I'm going to give more weight to that than what any other regular person would say. You can't have those. And thank you, Squirrel. I appreciate that. It's a small town girl, yeah, for sure. So the judge is the one who has to decide then whether or not what your perceived bias or your perceived issue is, whether or not that is something where for cause the judge would remove you, or whether he or she thinks that this is not something that would make you an inherently biased person and not able to sit on the jury. So if the answer the judge gives is, oh, okay, well, Miss Davis, but I'm going to leave you on, I don't think that you have a bias that against either side, then it's up to either the defense or myself to challenge that, and either challenge it for cause and try to give some sort of an explanation to the judge as to why that person should be removed for cause, or we can use one of our peremptory strikes where we just say, again, for any reason, thank you for your willingness to serve, but the people, thank and excuse juror number 2, whatever. After you got through those easy questions, then comes the more awkward part, I guess I'll say. So, depending on the type of case, there are specific questions that we would ask. So, for example, if it's a criminal sexual conduct case, those are extremely controversial, right? Like, nobody wants to think that these types of things happen in our small communities. A lot of people have had traumatic experiences in their own past, or their children have, or their nieces or nephews, or they're in the foster care system and they're taking care of kids that have had. All right, are we back? Hopefully it's a yes. I have my phone on do not disturb, or I should put it like officially on do not disturb. Focus. Yes, do not disturb is on. So, can everybody hear me? Again, somebody give me a yes or a no in the chat. Twins. I know, right? It'd be so fun. I always wanted to have twins. Somebody, yes. Okay, thank you, Star. Appreciate it. So anyway, going back to when those super sensitive questions are being asked about your own personal experiences, whether it's criminal sexual conduct or drinking or criminal offenses or something like that, you can have the opportunity to go into judges' chambers, and well, the defendant and myself or whoever's prosecuting and the defense attorney all go in there. But you don't have to say it in front of a courtroom full of people. So I think some people get very nervous about having to disclose these personal biases or personal issues that they might have. But keep in mind that it's not intended to embarrass anybody publicly or to humiliate them by any means. But we just have to know so that if it comes out later that, oh, by the way, yeah, I was, molested as a child, and that's why I wanted on this jury so that I could get justice for this victim. That's a huge problem, right? Those are the types of things that are going to cause a massive issue on appeal. And so we have to ask these questions. The judge has to ask these questions so that we can get a panel of people that are as unbiased as possible, so that the person has a fair shake. It's not just trying to win a case, it's for justice to be served. So there are times when people then, yes, do have that moment where they go back into chambers. And so, if it's something that the judge says, okay, yes, for cause, I'm going to release you. Sometimes the people don't even have to go back into the courtroom. They just have taken their stuff with them and they go out the side door. They maybe get the letter from the clerk to say that they were there to get excused from their employment. But again, it's not done to embarrass anybody. Now, once you are seated, and let's jump to, okay, everybody has gone through all of the questions, all of the personal biases, all of the issues that might have rendered you unable to sit on this jury, and say it's a 2-day trial. There's always the option that the trial is going to last longer than 2 days, because although the evidence might only take 2 days to present, as far as the prosecution going first, defense going next, if they are going to present any evidence, it could take days for a jury to be able to deliberate and come up with a unanimous decision, right? You can't have 7 versus 5 or something like that. If you cannot, after lots of deliberation and consideration, come up with a unanimous verdict, it ends in a hung jury. So it could take an hour to deliberate. It could take 10 minutes. It could take days. So keep in mind that as a juror, you've signed up for this, and now you're going to have to ride it out till the very end. Now, I had a question. What is the craziest story that you've heard from someone trying to get out of jury duty? Oh, let's see, Bill. Let me see if I can get this to show up here. Slide up. I mean, people tend to have the pretty basic reasons. Breastfeeding mothers are exempt. So, I mean, that's kind of interesting, right? If you're pregnant and due to give birth soon, also a reason that they will not make you sit for that. Medical issues where somebody cannot sit for hours at a time. I mean, obviously, we do get breaks occasionally, but it's not something where we can take restroom breaks every 10 minutes because somebody has to go and whatever. It's like, nope, judge kind of limits your water intake even when you're in there, so that we can avoid all of those extras. I don't know if I've had any crazy stories myself. Judge has shared a few stories about people that over his years on the bench have, agreed to jury duty or tried to get out of jury duty. But a few of them that I thought were pretty funny. One is a guy said, okay, I can do this. And then I think it was the next morning as they're coming in to start, he's like, I totally forgot. I'm getting married this weekend, and then we're going on our honeymoon. So his wife was pretty upset with him when she got home, and he told her, hey, I'm on jury duty for like 2 weeks. It's a murder trial or whatever the case might be. And she was like, no, you're not. We're getting married and going on our honeymoon. So other than that, I mean, there's not anything too crazy, I don't think. Nothing that I can think of off the top of my head anyway. So, are there any other questions? Debbie, do you think the jury in the Depp and Heard case are going to be totally unbiased? That's a difficult one. I think anytime you have a high-profile defendant or a high-profile witness, and in this case you have both, right? There may be that part of the jury that says, okay, do I hold them to a different standard because of who they are or what they've done? And that is very difficult to overcome as a plaintiff or a defendant, prosecutor or defendant, whatever, if it's a civil case or a criminal case, because you can't get inside their brains, right? We're trusting that the people that have agreed, they've sworn and taken this oath to uphold the law, to listen to the evidence, to not consider outside sources. They're not allowed to go to the scene if it is, say, it's an accident and they live by the scene or something like that. You're not allowed to go and do your own investigation. You're not allowed to look at news sources. When it's a high profile case like the Depp Heard case, everybody's covering it, right? You've got YouTube people covering it, you've got news outlets covering it. And for those jurors to honestly do what they have sworn to do, they have to basically shut off their social media. They can't talk about it. And the same thing in our like small town cases. You're not permitted to talk about the case with each other as jurors until everything has been presented. So when you go back in that jury room for a break, you can't talk about anything. And that's very difficult for some people. The other thing is we, as the people involved in the case, the witnesses in the case, the prosecutor, the defense attorney, say that there's somebody on the jury that I do know, they're an acquaintance, not to the point where they felt that they couldn't give an unbiased look at the evidence, but it's very awkward because when we're leaving the courthouse at the same time, I'm not permitted to even say hi or how's your day or, thank you for being here. Nothing. So for a social person like myself, where I'm usually chatting with someone or saying hi or smiling at them, it can be very difficult. I try to wait for all of them to leave first. And that way I don't have that where you run into them in the hallway and have that awkward, like, make eye contact, but don't make eye contact and keep walking. So hopefully people understand that in the jury selection process, same thing. When I'm walking into a room of 50 people or 100 people, and I know maybe 10 of them, I can't smile and wave and say hi. I have to keep those two things separate, your personal life and your professional life. And when you go to, everybody knows about Yoder's, right? Like Judge talks about it. And if you're from the area, a lot of people go there for lunch. When they're jurors, they have a button that says that they're a juror. And people from the general public aren't allowed to ask anything about the case. And that has led to some issues in the past where during these long, tedious trials, when they just are trying to go get lunch and somebody sees them talking to a person, it can raise these issues. And jurors have gotten called in to the judge's chambers when we get back from lunch. Hey, we heard you were talking to so-and-so. Was it about the case? You need to disclose this. And there have been times that during the trial, even things come up where someone overheard you talking about the case in particular at the local coffee shop, and you get removed. And that's why we have those alternates, not only for family emergencies or health emergencies, but because there are times when people get removed because of conduct that they had. And it's not, I don't think that people are intentionally trying to do that. It's the nature of people, social people especially. So, and hi Dale, nice to see you. Thanks for coming. So with that, other questions? Married duty, yes. Somebody who doesn't want to get married. I don't know how long ago that was or whatever ended up with them. So we'll have to see. Can you tell us the Discord for St. Joe County? I'm not aware of a particular St. Joseph County Discord. The Zoom court Discord does have different rooms. I'm not so bad with Discord. I get on it once in a while when I try to, but there is one if it's like /Zoom court, and I know that one has a separate room for each of the judges, and a lot of good other courtrooms too. Let's see. Give me some likes. Oh, thanks, Dale. Yes, being too opinionated. I don't know. I kind of like opinionated people, right? Okay, 25 years ago as a jury. Oh, also with jury duty, after it's all said and done and a verdict has been read and they've polled the jury, which means just they ask each of you individually, is this your verdict? Is this what you said? And if everybody, yes, agrees that was their verdict, then, case moves on and the person gets either let go or remanded for sentencing or whatever the case may be. But after you're all done, we do like, as prosecutors and defense attorneys, to talk to you if you're willing to talk to us. Sometimes it's just constructive criticism that you can give to us, something that you liked, something that you didn't like, what your thoughts were, what your concerns were. It can be extremely helpful to us in understanding why the case went the way that it went. And if there's something that we do that annoys the jury or is hard to hear, hard to see, is the PowerPoint presentation too much, not enough, whatever. So if you are on a jury and you are willing to speak to the attorneys afterward, we certainly welcome it. And not just speaking to attorneys, you can speak to whoever you want after the trial is over. So, yeah, it's kind of interesting. I know I've had some family members in the past, we're talking years and years ago, before I was even an adult, were on some pretty serious jury trials. And for some people, it's more, I guess, traumatic to hear and see all of the things that they do, and they just don't want to talk about it. With murder trials specifically, when you have a grieving family, you have autopsy pictures, you have these things that you just don't want to think about. It can be very difficult, and sometimes the jurors, once they're done, and they don't want to think about it anymore. They don't want to talk about it, and we respect that as well. We don't, hold that against you if you don't want to discuss it. Okay. The difference between a case being dismissed with prejudice or without prejudice. What that means is, with prejudice means we can't bring it again. So once it's dismissed, it's dismissed. Generally, that's when jeopardy has attached. So a jury has been seated, case is going, and either there's a not guilty verdict. Okay, well, then that's done. You can't bring the case again. Or if we decide as a prosecution, for whatever reason, to dismiss it mid-trial, which I've never seen happen, but I guess it could, then it would be dismissed with prejudice as to that count, because you can't bring it again once the jury has been seated. And then without prejudice obviously means that you can bring it again. And we use that, I would say, fairly regularly. There's times where maybe more information has come out about a case. And so instead of proceeding to trial, we dismiss it without prejudice. We get that information that we need, we recharge it, and start from there. And if that happens, they start from square one. So if they had waived their preliminary examination on the prior case, it doesn't mean they have to waive it this time. They can ask for their preliminary examination. Okay. Is it true that potential juror social media pages are looked at before they are picked? Occasionally, yes. And sometimes it's just like out of curiosity, right? Do I know this person? Do I not know this person? But if their profiles are private, then you can't really find out much about them. But sometimes you have people that you look at them, you think I know that name, but I'm not sure. So we do kind of do some background on them to see if we know them or not. Do you ever tell first-time DWI people don't hire an attorney? You didn't hurt anyone. Okay, so they're asking if with DWIs are operating while intoxicated or operating under the influence of drugs, if we say to defendants, don't hire an attorney if you didn't hurt someone, didn't cause any damage, because it's a standard plea. Obviously, as prosecutors, we can't give advice to the defendant, right? Like, our position is opposed to their position. But I do tell people that my plea offer isn't going to change whether they have an attorney or not, which I think is a fair statement, right? Like, this is what the offer is. And if you want to speak with an attorney, that's fine. I'm not going to penalize you for that. And if you want to get an attorney or you don't, the plea offer is going to remain the same unless there's some sort of significant change in the circumstances, or if there's whatever change in the evidence or something comes out that we didn't know, then of course, until you accept a plea and put it on the record, it's always subject to change or subject to being withdrawn. Let's see. Yeah, if you're asking me a question, please try to tag me. I'm really not great at keeping up on this. 17-week trial, the OJ case. Oof, that's a long trial. Again, there are times where in, again, bigger jurisdictions, not so much us, where the jurors are sequestered. So they're put into like a hotel so that they don't have the opportunity to see their family or friends or get a hold of newspapers, things like that. To my knowledge, we never had anything like that in St. Joseph County. We have had some high profile cases where we end up not being able to seat a jury for various reasons. One that happened recently is there was some issues with the juror notices going out. And so instead of getting the 100 jurors that we would expect for the type of case that it was, we only had about 36. And the problem with that is by the time you get through all of those initial questions about, do you know anybody? Do you have any personal biases, any issues? We were only halfway through the question list and we had gotten down to 11 people. So when that happens, it's very stressful. It's stressful to the victim. It's stressful to the witnesses. People have taken off work, that sort of thing, in order to be there. And so we always hope that that doesn't happen. Generally, with the high profile or types of cases that maybe have more of a trigger effect on people with their own personal issues, the judge will call in a panel for the morning, a panel for the afternoon, sometimes a panel for the next morning, just to make sure that we have the best chance at seating that jury so that the case can go forward. Because if you can't seat it, like this one that we had, it ends in a mistrial, which sounds really horrific, right? Like, oh, it was a mistrial, but it wasn't anything that the defense did wrong or anything that the prosecution did wrong. It's just a matter of we didn't have enough people, and by law, you got to have that 12-person jury in order to proceed. Okay. Cheeky Monkey's telling me that in the UK, if you're called to jury duty, your employer still pays you for the time you spend in court. That is wonderful. It certainly, if we had that throughout the US and Michigan in particular, where I am, that would be great. Unfortunately, right now, they're not required to pay you. They can't fire you. Like I said, they can't like penalize you for it. You're excused. However, if you're not there, you're not making the money, and your family, if they're depending on it, a lot of people are living paycheck to paycheck, and they can't take a day or two off, or that negatively impacts their ability to care for their family. Okay, what does it take for a jury to be kept from going home? Larry, I don't know if there's ever been a time where like, you're not going home, we're making you stay here. I think the judge has on occasion given the jurors the opportunity to stay if it's close to 5 o'clock and they feel like they're making progress and they're close to a verdict. I believe that there have been times where they let them stay past that, but I don't think they've ever required them to. Okay. Trial de novo. I mean, most of the time you're looking at a de novo review hearing, where it means that this is more in civil cases, I would say, with like family law, for example. If you had an evidentiary hearing, a trial in the court, and you appeal the decision of the court. So, like in family law cases, it's maybe because you have a family law magistrate, the front of the court, hearing the case, looking at the evidence, making a decision. You can then have a de novo review hearing where instead of having all new evidence and redoing everything, the judge would look at the transcripts. Most of the time, like in our county, they'll watch the video of it, they'll read the transcript, and I think he watches the video a second time before deciding whether or not the case was decided properly. And there is the opportunity in those de novo review hearings to bring up information that is new, that was not available to you at the time of the original trial. So if the decision was made and 2 weeks after that, something significant happened that you didn't know or couldn't have known, even if it's something prior that you didn't know about and couldn't have possibly known about, you can bring it up at that de novo hearing. But generally, they limit it to, I think, an hour and a half for each side to present new evidence. Okay, let's see if there's any other questions. I see unclean hands. Nice to see you in here. Okay, Bob, yeah, I think Judge is aware that his mic is lower, and again, I think it's because it's the mic picking up from over on the TV on the wall. I don't really know how to fix that. Oh, Dale, you were on a murder jury and then the defendant took a plea. There are times where the court will refuse to accept a plea after the jury has been seated. unless it's a guilty as charged, which obviously is not ideal in most cases, right? But there are times where the judge, if there is a significant change, maybe witness issues or whatever the case might be, that the judge will accept a plea other than as charged. But in general, if it's day of trial, as charged, or you go to trial. Be the Moment has a question. Can a juror be held in contempt? Yes, they can, and they have before. Uh, it's a civil contempt most of the time, but that can be up to 93 days in jail or fines and costs, right? So it's not something to mess around with. And the biggest reason that people would be held in contempt is willfully disobeying the juror summons. If you knew that you had it and you just simply refused to come because you don't want to, the judge can hold you in contempt. There are occasions where things that you say in court get you held in contempt as well. Sometimes where there's a juror that says, I don't even know why I'm here. If you put me on this, I'm going to cause a mistrial. It's like, oh, not the thing to say. Obviously, that's a person that we would challenge for cause from being placed on the jury, even if the person was to make it through and get seated. But definitely something that the judge can do is to hold you in contempt. Okay, let's see. An off topic, who's been sitting behind me in Zoom court? That's our new assistant prosecuting attorney. Have you ever tried a state level case at federal after the state level case ended with an acquittal? I have not ever seen that happen, and I would think that there's a jeopardy issue with that. I don't practice in federal court, so I guess I would leave that to somebody who practices in federal court to answer that. Why make an offer? Why is the charge reduced from the original charge? That's an interesting question. And it's very case specific, fact specific. Making a plea offer is, there's no magical formula to it, right? You have to look at how strong is your case? How strong are your witnesses? Is your witness able to withstand going through a 1 day, 2 day, 3 day, 5 day, 7 day, 10-day trial, right? It is not for the faint of heart, but you can't just give a plea offer because you have a victim who is stressed, right? There's like some sort of balance in there that you have to find. So I don't know. And things do change too. So if a case happened a year and a half ago and now it's just finally getting onto the trial docket, which is not uncommon. I mean, speedy trial, sure, there's a 180-day rule, but that's more geared toward people who are in custody in the Michigan Department of Corrections, like in prison, that we can't just ignore their case and make them sit. And then when they're getting close to parole, we're like, oh no, just kidding, you're going to go to trial on this. That's why they have the speedy trial in place. And for people that are incarcerated in the local jail awaiting their trial, they can request to have a PR bond if it's been 180 days and we haven't been able to take it to trial. But if there's any adjournments that are requested by the defense, that tolls that 180-day rule. So the judge has to carefully calculate, okay, if there were adjournments, what was the cause of the adjournment? Was it the defense? Was it the prosecution? Was it both? And decide whether or not that 180-day rule has been followed. For MDOC, though, it's not just, oh, you get out on a PR bond. MDOC, there are times where if you violate the 180-day rule, their case just simply gets dismissed, which is not ideal. Okay, let's see what else we have. Oh, I will say hi to little Mikey. I want to go see that little scamp. He's so cute. I honestly think he might have dwarf genetics and stay tiny forever, which is my dream because I love little tiny goats. I love them. What is HYTA? Okay, so Dale's asking what HYTA is. HYTA. That's Holmes Youthful Trainee Act. It's a specific act for people who have a crime that is committed between their 17th and 21st birthdays for certain instances, or their 21st and 26th birthdays. It's 26, maybe it's 24. I haven't looked at it in a minute. They keep changing it. But anyway, it's a statute that allows the prosecution to permit and then the court to permit a person to do this probation and keep it off of their public record. And then upon completion of the probation, it's wiped clear from their public record. There's still a record of it with the Michigan State Police, so that in the event they were to get in trouble again for whatever reason, it can come back to haunt them, right? But in general, it's a really good way for people who are young and do something really dumb to do a probation, prove that they can stay out of trouble and get that off of their public records. So for school purposes, for housing purposes, for job purposes, people aren't going to be able to see that you had that conviction. Okay. Oh, somebody had a de novo hearing, but in Maryland, it ended up with a whole new trial. Oh, that's terrible. I mean, to have to go through all of that over again. I feel like doing it on the transcripts makes it a lot less expensive, a lot less traumatic for people. And then being able to supplement that, I think is a good way to do it. So I guess I prefer how Michigan does it versus Maryland. Okay, let's see. Clicked a button. Any other questions? Yeah, people do give ridiculous reasons for trying to get out. Delete Law says he's coming to my town. He wants you to... Oh, joy. You know, it's helping people learn, I guess, is what I like to do. What's the difference between a good lawyer and a bad lawyer? A bad lawyer, oh, that's not very nice, Cheeky Monkey. Okay. Oh, thank you, Be the Moment, for the super sticker. I appreciate it. All right, about to wrap things up. Thank you for the kind words from my people that are watching. And let's see, most interesting charges I've had to prosecute. I don't know. I mean, it's been kind of run of the mill, so I can't really say there's anything too crazy and interesting. Okay. Yeah, a lot of times you're going to get that jury summons and then there's not a trial. So don't stress about it, right? Like people get all worried about it, but if there's not a trial, there's not a trial. Okay, let's see. Suzanne, I'm glad that we could put you at ease. And okay, for the final, before I head out of here, because 41 minutes is kind of long for you guys probably. Josie did not have any babies, and I think that she just isn't pregnant. So I'm pretty bummed about it. But she's back running around with the other moms and babies, so we'll see what happens. But we still have our 5 baby goats, and our other sheep are going to be coming soon for the kids for their 4-H stuff. So all right. David, I don't think there's any cases that I've dreaded because even with really unfortunate cases or traumatic cases, there's always that feeling that you're at least giving closure to the victim or the family of the victim, depending on what type of case it is. So, I don't dread it. I do get nervous, right? Doesn't everybody get nervous when they have a large presentation at work or a big project that's due? Definitely, there's that nervous energy, and you just want things to go smoothly. The idea is that justice will be served. So if we can do that and seat the jury, and the jury comes back saying, hey, we don't agree with you, prosecutor, as long as I've done my job and felt that I've represented the state the way that it should be, it is what it is. So juries sometimes come up with decisions that maybe we disagree with, but there's so many things that the jury doesn't get to hear that we get to hear, right? There's evidence that can't come in, and that's where I guess a couple more things on jury duty, right? There are times where there's a motion that is made or something happens where the judge excuses the jury to the back room, and we have a testimony, argument, whatever it might be, and the judge makes a decision. And whatever that judge's decision is, we're stuck with it at that point. Now, there are ways that you can appeal during the trial, but in general, talking most run-of-the-mill cases, if the judge makes a decision about whether or not this piece of evidence comes in or whether or not the testimony in a certain way comes in, it does change the dynamic of maybe what your case theory is. And if your theory was based around something that the judge ends up excluding, it may blow your entire case. So again, preparation is key on our end as prosecutors and on the defense's end. And we don't like to have surprises, right? The idea is that's why discovery rules are the way that they are. Each side, reciprocal discovery. You got to give them everything that you've got. And they give you everything that they've got. So again, you don't get into the situation where you're mid-trial and some bombshell gets dropped on you. So like what you see in TV, that doesn't really happen that way, right? So with that, I think this is probably long enough, guys. 45 minutes. But I know I've been AWOL for a while. We had spring break with the kids. I have some videos of Anna Maria Island that I'm trying to splice together and get a cool like travel video to put up. So as soon as I can get that done, I'll get it posted. And if you have ideas for other law videos or things that you want to know something about, drop it in the comments. I'll take a look at it. You can always send messages, that sort of thing. Check out the Discord for Zoom Court. Wheels is in here. I know he said thanks for the shout out. It is a really cool Discord. I do like it. I know Judge looks at it too. I've heard anyway. So careful what you say in there. Just be truthful, right? Sometimes the truth hurts and I can take it. But anyway, thanks for everything, you guys. It's been a lot of fun. I appreciate it. And go and do good things wherever you are. Thank you.